Okay, can you all see my slides? Yes. All right. So I'll get started. Hi, everyone. My name is Ziying Meng. So I'm a PhD candidate, just like Taylor said, who recently submitted her thesis like a week ago, 2 weeks ago. So it's still like everything's still very fresh and new in my mind. But yeah, today I'm presenting this book chapter is part of the hashtag hustle. The title is Entrepreneurialism, Precarity, and Self-Governance, and I explore this concept of cross-platform creator labor, basically looking at a group of creators who operate across Chinese and US-based social media platforms and economies. So, as a Chinese person myself living in the West, I'm always interested in comparing the experiences of navigating different digital ecosystems. So, one is driven by American tech giants in Silicon Valley, and the other is driven by Chinese tech companies that are getting more and more prominent on the global stage in recent years. So, the context of my research is in this kind of multi-platform, globalizing digital environments. And I'm particularly interested in the creators who operate between this kind of global space, like between Chinese and US-based platforms. So to give you some example here, we have Pamela Riff, who is a German fitness creator who has a large online following on YouTube and Instagram, but she's also a top tier influencer on Chinese platforms. A lot of like Chinese people in China following her content to do workout, even though like Pamela doesn't speak Mandarin herself. And Li Ziqi, who is a Chinese top tier creator, also has the largest Chinese language YouTube channel in the world. And American YouTuber Mr. Beast, who is one of the largest YouTubers around in the world, and I think it's early last year, he joined Chinese video sharing platforms Bilibili. So apparently, I didn't interview all of these influencers, but they are the kind of like prominent examples of the types of cross-platform creators that I look at. And my book chapter in the hashtag hustle draws on 16 content creators' platform practices and experiences, investigating their work and labor conditions. And it builds on the studies of creative labor in the global Wanghong industry. So Wanghong is the Chinese term for internet celebrity and social media entertainment. So as for the methodology, I use digital ethnography as the main approach, collecting data through interviews, online and offline participant observations with 16 creators. And here is a map showing where my participants were located in when I conducting the interviews with them. And I also conducted participant-led cross-platform walkthroughs. That is, participants, they will show me how they used and understood different platforms, the features and functionalities. And I also use autoethnography to reflect on my own experience as a cross-platform creator and qualitative content analysis on my participants' online profile and posts across platforms. So mainly for informing the overall context of research. Now, I will share some snippets of my findings from the paper. I wouldn't share everything because more detail apparently will be in the article, so I encourage you to check that out. But anyway, becoming a creator is entrepreneurial in nature. That's why I use entrepreneurial cross-platform strategies to describe creators' practices. As my participant, Volker, who is a German creator, he can speak fluent Mandarin. He told me that if you have a reach on social media, you can do any business you are interested in with it. Sometimes you just start somewhere and don't really know where it ends, but find your way while going. So these creators not only treat content production as a type of entrepreneurial work that I can build on anything based on that, but they're also entrepreneurial in a way they use multiple platforms. So it's very common for creators to test around different platforms to find out which one actually work for them. So an example here is from Ella, who is a Chinese creator making travel videos with her British partner. Ella told me that how she shifted her focus from YouTube to Chinese platforms. She said, it was mainly because our initial development on YouTube didn't go well. So now we focus more on our Chinese audience on Chinese platforms. Some creators are like Ella. They started on YouTube and then gradually shifted more focus on Chinese platforms once they find that it's easier to grow. It's not really easier to go, but then some maybe their content tap into some niche area that's become popular, so that they might shift it more focus on Chinese platforms. But then other creators, they might go the other way around. So some creator participants who already have a large online following on Chinese platforms, they want to grow on US platforms to seek a more sustainable way of monetization. So here is a quote from a Toronto-based Chinese creator called Gloria. She says, I rarely do sponsor ads, so I really want to grow my YouTube channel because they have ad revenue sharing. If I could bring my Bilibili followers over to YouTube, I wouldn't even need to take on any sponsorship now. So these creators, they look for opportunities to diversify their income streams and minimize the risk of instability. Now, since we mentioned monetization, I want to talk about the paradox of empowerment and precarity that I found that a lot of creators experienced. So these creators are empowered by their multi-platform online presence, as it could bring them more monetizable opportunities. But the more platforms they use, meaning that the more rules they might need to navigate, which could add up the overall workload of their platform operations. So when monetizing their content, one of the rules that creators might need to follow is this feature called Creator Marketplace. It's an integrated commercial service on social media platforms, offering features for influencer marketing, campaign management, and analytical dashboards for creators' channel metrics. It's basically how nowadays these platforms try to be the intermediary between creators and the brands. So platforms are trying to take the work from MCNs and agencies somehow. So CM is not that widely used on US platforms, but then on Chinese platforms is becoming the norm in the industry. And this image, this form showing like a simplified version of CM on Xiaohongshu or Rednote, how the whole collaboration between creator and brand and also involving the platform. So Chinese platforms, they encourage creators to partner with brands through content production, showing that everyone has the potential to leverage online influence into commercial benefits. But Chinese platforms also require commercial transactions to be made through CM interfaces, because that's how these platforms can charge a part of the commission fees from each transaction. So lots of creators feel ambivalent about it, which more detail you can also find in the paper. Let's move on. So another challenge is from platform poaching and relational labor with platform workers. So platform poaching is a concept that I use to describe the talent scouting process of recruiting creators from competitor services by offering these creators platform support and monetary incentives. So platform poaching is very common in China because the platform industry is super competitive. And how things works is like this. Just like my participant Luke from UK, he says that someone on Bilibili messaged me saying, hey, we got this new Tencent video platform. Do you want to join this? I thought it was a scam actually. So I wanted to prove that he's from Tencent. So he proved it. Then he added my WeChat. And later on, this person from Tencent offering one-on-one support with Look. So these platform poachers assist creators by providing support, but it also shows the uncertainty in a competitive platform economy that involves a lot of human labor. So in the last part of my paper, I elaborate on the self-governance tactics from cross-platform autonomies that includes cross-platform profile management to create multiple accounts on different platforms in a way to deal with the issue with copyright infringement. That is someone trying to steal the creator's content and repost it, re-upload it to another platform without authorization. And impersonation, that is someone trying to fake their identity to be the creator themselves. And then another tactic is self-curation on content distribution and online performance, which is a must for creators to comply with different platform regulations, navigate the contractual relationship with Chinese platforms, because some creators, they sign a temporary contract with platforms in order to have like exclusive distribution rights. And then they're also trying to maintain their creative freedom of doing the things they enjoy. So to sum up, cross-platform labor on Chinese and US-based services is a risk management strategy to mitigate precarity and platform dependency in an unstable and competitive platform environment in influencer industries. And ultimately, I argue that cross-platform creator labor has become an imperative to thrive and survive within the globalizing influencer economies. And that's all from me. Thank you for listening.
Thank you so very much. I think you've given us so many things to consider and to discuss, which shortly we will do. But before we get there, I guess we'll continue thinking about this relationship between creators and platforms and this issue of dependency with the work of Tjas Petroc, who is a PhD researcher at Tilburg Institute for Law, Technology and Society at Tilburg University. And she will introduce us to her chapter, Content Creators and Digital Platforms, the Potential of Selected EU Frameworks to Address the Issues of Digital Labour Beyond Platform Work. So I will hand it over to you.
Thank you very much, Taylor, for this introduction. And also thank you very much to the editors for really wonderfully steering the whole process. It was a very pleasurable and amazing experience to be able to take part. I will share my screen and you should be able to see my slides, I hope. So indeed, like Taylor said, I will briefly introduce my chapter on content creators and digital platforms, which focused primarily on the issues related to digital labor and the capacity of different EU regulatory frameworks to address it. Perhaps before I go into it, this was a bit of a side passion project of mine. It's not directly related to my PhD research, but nonetheless, I think it's. I was excited to look into it because it relates, as kind of my main research interest is, to the creation and distribution of value through and on digital platforms. And in this sense, it tries to offer some form of a critique. Okay, I need to, yes, perfect, now it works. To give you a brief introduction, so I focused on the revenue model of digital platforms like YouTube. So I chose YouTube as an example and focused on the role of content creators therein or thereon. I'm sure we all know platforms like YouTube. So it's essentially a video sharing platform that acts in economic terms as a multi-sided market. So it brings together various parties. We have on one side content creators that rely on it to showcase their work and creativity. Then we have viewers that are interested in this content. And we also have the third party, which are the advertisers interested to showcase their ads to viewers through or on the videos that content creators provide. So this advertising revenue is kind of the basis of YouTube's business model and Google's more broadly, and is also the subject of critique. So in this slide, I only focus on content monetization through this, it's called partnership program that YouTube content creators have with the platform that allows them to obtain a part of a portion of the ad revenue when they reach when they fulfill certain conditions, such as a number of views, subscribers, and so on. In the chapter then, I looked into how the platforms like YouTube generate and obtain value on the basis of this content creator's work, and then I problematized it as potentially unfair or exploitative, and like I said, looked into the potential of different EU regulatory frameworks to address this potential unfairness. To kind of ground the discussion theoretically, I relied on the critical potential of the notion of digital labor, perhaps maybe following on what Ziying said, right, and denoting this empowerment capacity that platforms may have. Digital labor also on one hand highlights that this can be something that steers autonomy and facilitates flexibility in work. But on the other hand, the more critical literature, of course, also highlights its potential for exploitation by focusing on how value is produced through the way the platforms facilitate and enable interactions or transactions, because they are placed in the central position to be able to channel the bulk of the value to their own interests and to their own benefit. And here I mainly then relied on Sabine Pfeiffer's work, who applies a rather, standard approach to use and exchange value to digital labor specifically. So on one hand, she differentiates, or she applies the concept of use value, so the value in human labor and efforts that content creators put in the production of their video to satisfy, on the other hand, their creativity, but also the viewers' needs and expectations to receive quality content. And between the exchange value, which is then the revenue or the amount received for product on the market via the auctioning mechanism that YouTube employs when ads are shown on videos. And of course, we can then appreciate that it is this latter exchange value that is kind of at the basis for reimbursement for revenue sharing, which then also implies that the human value or this production efforts and capacity that content creators needed to invest into making their videos is disregarded, which could then potentially imply that there is some form of unfairness or, like I said, exploitation, in the sense that if this is disregarded, it's also not properly accounted for and not properly reimbursed. So then I looked into the different applicable EU regimes beyond the currently, I believe, adopted platform work directive. So I didn't treat this as work as such, but looked into other regimes as building on and complementing work of Barnard, which was, I think, instrumental and kind of a groundbreaking in this domain. And I looked into kind of 3 areas of more economic or market regulation frameworks. On one hand, platform regulation, so specifically the platform to business relations regulation, and then the recent DSA, Digital Services Act, and DMA, Digital Markets Act. In the second step, also consumer protection framework. Without going too much into details, I figured out, or I realized, that those frameworks are on one hand focused very much on ensuring transparency, on ensuring access to redress mechanisms, and setting up some form of procedural requirements for the markets to function well from accessibility or contestability point of view, and especially in the consumer protection framework, facilitating information disclosure. So as such, they're not really challenging the revenue distribution or the business model as such. And as Rachel Griffin, which I'm really happy that she will discuss the chapter later on, notes in one of her papers, this kind of gives the impression that the way the value is distributed is fair because it's precisely the subject of these transparent, procedurally sound transactions by well-informed, rational market participants. So I looked perhaps in an unlikely candidate for perhaps challenging this revenue model a bit more directly, and that is competition law. And here, of course, I need to put forward a caveat that this would be a bit more innovative or creative application of competition law that would be a bit more sensitive to substantive fairness aspects beyond just the procedural ones. And here I looked especially in the prohibition of unfair prices and trading conditions in Article 102A TFEU, because it has the potential to tackle exploitative abuses of dominance. So where the dominant party, which we could say YouTube is, accrues benefits that it would not be entitled to would it not be in that dominant position. Then I looked into the case law that would provide some form of elements to kind of set up the legal test to establish when this revenue model could be considered unfair. For example, if the conditions are beyond what's strictly necessary, if they're arbitrarily imposed, if they're disproportionate, and so on. Or we could even look more directly in the differences between cost and price under the unfair pricing legal test. Again, we can go into details in the discussion. So I thought that this might be, again, if applied a bit more creatively and innovatively, with a bit more sensitivity to unfairness, to the nature and functioning of business models, it could be a contender to challenge this alleged unfairness. Just to conclude, of course, I am aware that ultimately a success of such an intervention would depend on how we establish what is fair, what would be a fair distribution of this value that is created on platforms by means of relying on content creators' work and labor. It might be an arbitrary to some decisions. On the other hand, it might be a political decision that would necessitate hopefully a wider democratic deliberation. And that's why I conclude the chapter also that perhaps there is solution to be found not so much in the regulatory frameworks themselves or the regulatory action by the EU, but more in the unionizing action of the content creators themselves. There are some initiatives already emerging, but I think industrial action, I think, could be one possible response and a form of counterpower to challenge those kinds of models a bit more substantively. Thank you very much for your attention.
Thank you so much, Tjas. A lot of things to grapple with there, especially this big kind of question you ended with of how do we make sense of, or like how do we begin to think about what constitutes fairness in this space, and how do we operationalize that. So really looking forward to having a discussion with you all about both of these amazing chapters. And to begin that conversation, we're really delighted to have two respondents join us whose work really speaks to some of what has been raised. And so I want to first invite Shan Huang, who is an assistant professor at the Center for Media and Journalism Studies at the University of Groningen, to offer a provocation and response to Ziying's chapter.
Thank you, Taylor, for introducing me. And also, thank you, Ziying, for writing this very timely and great chapter, and also for the effort of the editorial team to put this book together. I think it's a wonderful project, and also the pleasure is all mine, like Kalina says, that thank us for taking the time to read, but actually I think we are very grateful that there is an opportunity to get involved with this work, and also kind of like engage in a discussion. And so for me, I think Ziying provided a really great overview for the transnational elements and also the trans-platform dynamics for content creators engage with their work. And then I think especially in terms of the way that she really speaks, really kind of elaborates on the necessity and also the traction of cross-platform content production. So that is something I think is very valuable in this field. And especially she kind of spell out what are the different monetization schemes. For example, the creator markets, the community guidelines, and also all the platform affordances, how these concrete elements actually contribute or restricts the content creators' content production practices and also their precarity and also their empowerment. I think those are really important elements there, and I will kind of elaborate a little bit more on how I understand her contribution. And also I think it specifically highlights this practice of platform poaching. I think that is something I haven't, maybe it's my limited knowledge, but I haven't read these kind of discussions somewhere else. So I think that's also a great contribution. So for me, the most fascinating part is actually the transnational elements of this chapter, and specifically fascinating and timely because of the current geopolitical dynamics and also developments. We all know that a month ago, there was a lot of hype and discussion and attention, not only from the academic community, but also in general from the public media, focusing on the trend of so-called TikTok refugee, moving all the US TikTokers moving to Xiaohongshu, moving to Rednote. And so I think, I mean, this development has taken a little bit of dampened speed right now, and I'm assuming quite a lot of US TikTokers have left Xiaohongshu as well. But I think it's still a great moment for us to start thinking about this transnational trans-platform content creation dynamics with a very, how to say, like potent influence by impacts under the geopolitics that a lot of times we kind of like take a step back and then don't really talk about that. So I think Ziying's work really, I mean, even though this chapter doesn't really talk about that specific event because this is written before, but I think it provides a really great starting point for the discussion about that. And so that is one of the most fascinating parts for me about this this chapter. And also I think Ziying really speaks, writes really well in terms of how the platforms position and also frame themselves differently when it comes to the monetization and also the commercial transaction parts. So what I can see is a different level of platform paternalism. So if we look at the more Silicon Valley platforms, they frame themselves more as a, how to say, like a facilitator or collaborator or partner for the content creators. But so as Ziying pointed out, that's on the Chinese platforms, there was a lot of how to say, like the business transactions and the commercial transactions has to be done within the platforms. And then that shows a certain level of next level of platform paternalism in terms of the platform really tries to regulate and also trying to shape how the content creators engage with these brand deals and with the monetization, the potentials. So I think that is very interesting. And based on that phenomenon, I want to point out that probably like the last decades, a lot of discussion about how platforms play an intermediary role is really quite focused. A lot of the focus are on their algorithms, are on their curation power. But I want to highlight that in Ziying's chapter, we see a return of the more traditional intermediary function, which is the middleman function in terms of, oh, I'm just going to get the platform just going to get the commission fee between, and then that is also something that is not something new to the way how middleman works, but I think it is a shift in terms of how platform works. when it comes to the influencer industry. So I think that's also something that I think it's great that Ziying highlight that. But based on that, I also wondering whether Ziying has any observation or analysis already about why these two very different model of monetization and also the model of the relationship between the platform and the content creators differ so much in the Chinese market versus the Anglophone markets. Because as you said, you point out clearly in your chapter that this model, this very strict dealing within the platform model is very prominent and very dominant in the Chinese market, but not so much in the Western market. So I really love to hear a little bit more about that, and then also maybe also all the participants who have the expertise to share with us on that matter. And then I also would like to kind of like point out that it's not only the community guidelines or the monetization scheme that's embedded on the Chinese platform that make this possible, but also they have a lot of other affordances and features on the platform that really reinforce this kind of within the platform trading. So for example, it is not possible for, at least on Xiaohongshu, it's not possible to include your contact on other platforms or accounts information on other platforms to be displayed on the platform on Xiaohongshu. And also if in the DMs, if you send your contact info, it will be automatically blocked. So these are the things that I think are also very interesting to think about how platform infrastructure play a very important role in the monetization models. Yeah, and then the other, am I talking too much? Yeah, it's just a very fascinating chapter, and I have a lot of thoughts on that. So in terms of the other point that I want to highlight is that it's especially interesting when I read that there are different attitudes towards account impersonation or unauthorized content transfer between platforms among these content creators. Some people think that is not a big deal. It actually boosts their profiles. But on the other hand, there are some people who are more kind of concerned about that. So I'm also wondering to what degree it has something to do with the different visibility modes. So what Crystal has written in her previous work about, for example, there is this persona-based visibility, and there's also this post-based visibility on different type of platforms, and how has that influenced the content creators' attitude towards persona theft or content transfer. So going back to my point about transnational elements, I'm gonna end there. I would love to hear from Ziying that how do you see your insights in this chapter being applied or challenged to analyze the US TikTokers' potential migration or potential non-migration? What are the developments regarding these transnational MCNs' role in the influencer industry in that sense? So, so that will be kind of like, yeah, my curiosity in that sense. I hope I didn't take too much of everyone's time. That's my comment.
Thanks so much, Xian. These are like great comments, and a lot of stuff that you pointed out. I feel like if this webinar happens like 2 weeks ago, I'm definitely gonna put that down in my thesis contribution in the conclusion chapter. So these are lots of good points, and I feel like a short book chapter with only 6,000-7,000 words cannot really elaborate fully, because I feel like when I was writing that chapter, I trying to like jam pack a lot of ideas in there, but didn't really like explore very deeply, but just like only focusing on this idea of digital labor. But then, as you said, like there are lots of things that I can actually like discuss further. Because I guess that we don't have that many time, so I would just like keep my answer very short to answer some of your questions that you raised just now. So why there are different kind of creator management model between like Chinese and US based platforms. I think that is because like US platforms, they are trying to rely on this kind of like automatic algorithmic way of managing their creators. But then Chinese platforms, on the other hand, they rely more on like using human labor to manage their creators instead of like just relying on the automatic methods. So in that way, it's also because US-based platforms, they don't really treat creators as an important stakeholders. Unlike Chinese platforms, they consider creators as a very important part of their ecology, so that they offer lots of supports. These kind of support, including monetary supports, but also like web traffic of support. If your content is in line with the platform's values, then they will give you lots of support, so that the Chinese platforms can recognize creators as important stakeholder, so that like they are all also like more willing to invest in human labor to assist with these kind of creators. So that I guess that's the reason why you can see platform poaching happens a lot on Chinese platforms, but not so much. I wouldn't say it never happens on US platforms, because if you look at the history of Facebook, they are also trying to do this kind of thing, like launch campaigns to attract like people to join. But then it's just not spending that much of efforts in recruiting creators. I guess another reason cause this kind of difference is that in the Chinese Wanghong industry, there are a lot more competition going on between all of these platforms. Like it's like a kind of hyper platformization and inter-platformization, meaning that it's more competitive. And even though it's competitive, that all these platforms, they still have integrated features that allowing you, for example, you are on Red Note and then you can still sell stuff and then to Taobao, because these platforms are like collaborate with each other. So I guess like that's the reason why we can see different kind of creator management styles, so that for creators who need to survive in both of the ecologies, they have to know what is really going on, and they also have to know how to play the game in order to increase their online visibilities in these two ecologies. So that's some part. I guess I can keep talking, but I feel like I should leave some time for our other contributor. But yeah.
Yeah, maybe we'll pause, because you raised so many interesting points, and then let's see whether at the end we'll circle back to that. But thank you so very much. So I would love to add Rachel Griffin to the conversation. She is a PhD candidate and lecturer in law at Sciences Po Law School in Paris. So Rachel, over to you.
Yeah, thank you so much. Thanks a lot for the invitation. And yeah, just to add to what's been said already, congratulations to both of the authors on these super interesting research projects. And yeah, it's really great to have this whole book open access, and I'm looking forward to diving into some more of it as well. I'll try and keep my comments as short as possible to maybe leave some time for other people to ask questions and so on. So yeah, Tjas, congratulations again. I found this chapter super interesting. I think it's like really helpful and clarifying on really sort of diving into these kind of relationships between content creators and users and platforms, really as a set of economic relationships. And I think this is a perspective that's maybe overlooked sometimes in a lot of the literature around kind of regulation of online content and online expression. That tends to be much more focused on the sort of the political discourse side, and less on the sort of how these platforms and their governance practices are really shaping our kind of culture industries as an economic sector. And I also found your critique of some of the different EU regulations in this space really interesting and really relevant. I'm very much on board with what you're saying about how this focus on sort of disclosure requirements and sort of procedural protections and trying to ensure these kind of fair market transactions, but without really addressing the sort of underlying commercial relationships and power dynamics, that this is really incomplete. And I think that, yeah, this is a big flaw of the EU legal framework at the moment. So then in that context, I think that your analysis of competition law and how that could be a way to kind of intervene more in the substance of these market transactions and the kind of power relationships there is a really interesting and promising idea. Especially because I think, especially, when we look at these platforms like YouTube, I think it's precisely the market dominance and the size of this kind of very small number of enormous platforms that makes their practices so problematic. It's because they have such a dominant role in the online media ecosystem, and obviously competition law really speaks to that. But I have maybe a few questions that were raised for me. I really have to apologize because I lost connection halfway through your presentation for a few minutes. So if you actually already addressed any of these questions, I'm really sorry, but they're based on my reading of your chapter, which, as I said, I found really interesting. So actually, one thing I'm wondering about is because some of the legislation that you discussed, I mean, especially the platform to business regulation, and to an extent now also the DSA, for example, they have actually already been in place now for some time. So I'm kind of wondering if, to your knowledge, there are actually any interesting examples of content creators actually making use of these different legal avenues or sort of grounds for legal claims in practice. Do we see any examples of them being mobilized successfully or maybe also unsuccessfully, which might also kind of illuminate a bit more like what they could achieve? And something else that I wanted to pick up on that you also mentioned at the start of your presentation is that your legal analysis is really mostly focused on sort of distribution of revenue between platforms and creators. But something that you also mentioned that I found super interesting is how these kind of content curation and remuneration systems, I think in your words, they kind of channel creators' creativity into modes that are most profitable for the platform. And this is also something that I'm kind of generally very interested and concerned about in my work. I think that it's not necessarily good for sort of media and culture industries to have everything sort of algorithmically boxed into these sort of particular modes of expression that are conducive to online advertising and e-commerce. And I wonder if you maybe see a bit of a danger that some of the legal regulatory approaches that you discuss, and maybe also even this idea that you discuss at the end of how maybe kind of workers unionizing to demand better working conditions could be another avenue. But I mean, if these avenues are really focused on just trying to distribute a bigger share of advertising or e-commerce revenue to creators instead of platforms, like, could that just incentivize that our online content becomes even more centered around e-commerce and consumerism, because that's where the ultimate revenue is coming from that the creators are now getting a bigger share of? And then finally, I think this also maybe relates to me to a bit of a tension that I thought was kind of present for me when reading the chapter, and then I'd be really interested to hear your thoughts about. Maybe there's like a bit of a tension between the theoretical framework that you're using and some of the analysis and the conclusions in the more legal part of the paper. Because, kind of, as I would see it, some of these kind of like Marxist perspectives and this sort of more like Marxist scholarship that you're using to describe and to analyze digital labor, I guess according to that kind of perspective, exploitation is not just workers being exploited because they're not getting paid enough or they're not being treated well, and then the solution is for them to be paid more or treated better. But rather we would say that exploitation is kind of an inherent feature of work in a capitalist system where control of economic resources and the means of production is concentrated with a few companies, and then most people don't have access to those resources, so they have to sell their labor to survive. And if we apply that logic to the regulation of online content creation, and we say that the means of production are the kind of the digital hardware and software infrastructures that are needed to create content, to share it with people, then I guess maybe we can't really redress exploitation just by having better pay or better conditions for content creators, but that would rather kind of point to questions about, okay, so who owns and who controls this infrastructure? Could we have more sort of democratic forms of control of these kind of communications networks? So maybe to finish, I mean, I know it's a huge question, but do you see any possibility in the EU legal framework or maybe in other avenues to sort of redress exploitation in this broader sense and maybe have kind of more collective control over the platforms that are being used for creativity and online content creation? So yeah, sorry, I know there's only a few minutes left and it's a lot of questions, but yeah, thanks again. I really like the chapter. It's very thought-provoking.
Thank you so much for these really thoughtful comments and questions. I'll try to be brief. So your first question was about examples of content creators using or relying the instruments like DSA, platform to business regulation, and so on. I am not aware of them because the legal analysis part was more theoretical than practical. So you gave me an idea for a really nice, more empirical follow-up study to this, to indeed explore how those frameworks might perhaps be used by creators themselves. But like I said, I'm not aware of any cases right now. So in terms of your second question, I think you were kind of getting at that if we would address this under the current frameworks, in essence, we would further legitimize the exploitation and appropriation of value by saying, okay, if you pay them just a bit more, then it's fine. Or perhaps I misunderstood that, but I think there is indeed a danger always, and now I will maybe rely on, or I want to link this to your third question, because I think it's also very essential, and it's something that I come across continuously, because we have this huge blooming critical literature that's relying on Marxist and other theories that's really trying to understand the digital capitalism in all its formations and critique it and propose better models. But then whenever we're trying to translate this into actual EU legal frameworks, I think, yeah, you're right, that there is a tension, because EU as such is built on the idea that we need to create a common market. So it's inherent in the way the EU kind of approaches things that the market is the mechanism that will regulate it. So I think you're right in saying that there is a tension, and I think I agree with you that those critical ideas cannot be simply translated into EU frameworks as they are right now, because I think I see them primarily as market building tools. And we really see that when we analyze the platform regulation mechanism, but also other, the plethora of all the other acts that have recently emerged, right? Those are essentially instruments that uphold the internal market. So then to square this, well, it feels sometimes right indeed to trying to fit a square through a round hole, because we're trying to kind of critique market facilitating mechanisms by saying they should be less grounded in this idea of the markets. So perhaps what I think might be needed, I'm skeptical if it can happen, but it might be welcome, is to have a broader, like I said, political discussion. So not on the level of agencies enforcing those acts, but like among the demos of the EU, on what do we want to have from these platforms? How do we see them? How do we see them benefit us? How do we want them regulated? And perhaps explore some other means of approaching that through utility regulation of or something else. But I don't see right now a way to effectively challenge this inherent exploitation of digital capitalism more broadly through the mechanisms as we have them on the EU level, at least. Thank you.
Thank you both so much. I'm mindful of time, but perhaps I'll open the floor for any brief reflections in our final few minutes together, if anyone would like to. To add anything in light of what's being discussed. Okay, well, I feel like we could continue to dive deeper into many of the points that have been raised, but instead of opening up more kind of topics that I think warrant lengthy kind of discussion and deliberation, I might instead thank you all so much for your time. Thank you everyone who's attended, and for the authors and discussants for their really thoughtful contributions. It's been so wonderful to hear you talk about the work and to think through some of the really big ideas that it raises. So thank you all.
Thank you.